Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, we're back in Callaway County with attorney Jeff Roberts, and we are going to talk about the Social Security Disability Form 3369, which is actually the work history report. Jeff, good to see you again.
Good to see you, Jim.
So we're going to jump into these reports, and let's talk a little bit about Social Security Disability Insurance again before we get started. SSDI.
Yes, Social Security Disability Insurance, or SSDI, is the program administered by Social Security Administration that pays out disability benefits to people who have worked enough quarters to meet what's called the insured status requirement. So they've worked and paid in enough to Social Security that they can receive disability benefits, and now they're no longer able to work because they're disabled for whatever reason. It could be a disease, could be an injury, but that's SSDI. Now, the form that we're talking about, though, would apply also in an SSI case or a Supplemental Security Income disability case. In SSIs, even if you haven't paid in enough, if you have the financial need and are disabled, then you can receive SSI disability benefits as well.
And again, for the listeners, this is to differentiate from normal Social Security retirement benefits. This has nothing to do with that. So if you tuned in, sorry, but listen along, you might learn something. But again, this is when basically a disability is involved.
Right. If you filed for Social Security disability or SSI disability, Social Security Administration administers both of those programs from that standpoint. And when you do make your initial application, and first off, we'll get into whether you have an attorney or don't have an attorney at that initial application. Normally, when someone calls me up and they have not filed for, made the initial application for disability, I advise people to make that application on their own without an attorney being involved, without me being involved. And the primary reason for that is that statistically speaking, the vast majority of people are going to be denied at that initial application. And there's some forms that we're going to talk about. The primary one here, the work history form today, but you'll fill out some forms, let them know what your medical problems are and who you're treating with. Social Security will get that information. They'll make that initial determination, and in all likelihood, about 3 months after the initial application, you're going to be denied, 3-4 months out. If you are one of the very few who is granted at that initial application, it's because of the severity of your medical condition. There's nothing, in my opinion, that an attorney is going to do to cause the case to be granted at that initial application level from that standpoint. But if you hire me and I'm involved in the initial application, I've done work on the case, then I've got to charge an attorney fee because I've done work on the case in that situation. And I don't like to charge an attorney fee when I don't think I had a role in it being granted. So I usually tell people, save the, if you happen to be one of the very few that's granted, there's no sense in paying an attorney fee. Wait till you get that initial denial in, and then reach out to me, and I'll sit down and talk with you, and we can see if I can be of help to you at that point in time from that. But the initial application, I just don't think there's anything I'm going to do at that level to cause it to be granted. And I've talked to other attorneys that feel the exact same way I do and have the same philosophy that they tell people, make the initial application. When you get that first denial, come in to see us. So when you make the initial application, and you can apply a couple of ways. One is online. If you're computer illiterate, you can get online, go to ssa.gov and file your disability application that way. If you're not as computer illiterate, you can call your local branch Social Security office, talk with them, and they can set up a phone appointment and take the application for you. After that initial application is filed, then Social Security is going to send you some different forms. You're going to get a medical release that you have to sign so they can get access to your medical records. You'll get a physical activities report that we can talk about in a different episode. In one of the forms, though, you're going to get, in one of the very important forms, you're going to get to work history form, work history report, which is the SSA form 3369 form. In completing that form is going to be a integral part of that initial application.
And so let's back up and talk a little bit about Social Security disability to begin with. That's actually a federal program. And as an attorney who practices in this area of law, you're actually licensed in all 50 states, right?
Correct. By the Social Security Administration, yes. I can handle Social Security cases before the Social Security Administration in all 50 states. And in my career over the years, I've probably handled Social Security cases in 10 or 12 different states from that standpoint. So yes, I can handle those in any state in the country, and have handled them in multiple states and multiple hearing offices in different states. So.
And if you're listening to this from outside of Kentucky, something you may not know about Jeff Roberts if you're just now finding this podcast is he also has an extensive background in personal injury and workers' comp. But both of those are limited to the state of Kentucky, but it's the Social Security disability practice that is able to go beyond the borders of the Commonwealth.
Correct. That's the only practice. The only thing that I handle outside of Kentucky is Social Security disability.
So Jeff, let's jump into this 3369 form. Kind of what does it do? What's it for? And how complicated is it to actually fill out?
The form, it's designed to give Social Security information about the jobs that you've done over the last 15 years. Social Security looks back at your work history over the past 15 years. Something you did 25, 30 years ago, they basically kind of consider those job skills pretty well gone, or things that the industry's probably changed some, so not as relevant. So the past 15 years is what they are looking at, and that's what this work history report is for. It's to give them more information about the jobs you've done over the last 15 years therein. So, the first sheet asks you to identify the job title that you had in the type of industry that you were in from there, and then the period of time that you worked for that, because that does come into play. If you only work for an employer for 2 months, they're probably not really going to consider that a job that you've learned all the skills in, from the standpoint of what they're looking on, what you can go back to doing when they look at your physical restrictions from there. But so, some job titles, you kind of know the industry. If you're a waiter or a waitress, you're in the restaurant industry from that standpoint. But others, you can be assembly line worker. Well, or you're an assembly line at small engine facility or a plastic extruding facility, and so or it could be in the garment manufacturing industry. So then they're asking the type of industry that you're in as well, to get to figure out what skills that you have from the job title that you held.
And so within this form, there seems to be a main page that's kind of a summary page, and then I think you explained to me that each job that you've had actually gets its own separate page. So it looks like a lot of documents, but it's because you've probably had more than one job in the past 15 years. Is that kind of the idea?
To some extent, yeah. If you've only had one job over the last 15 years, you fill out the first page and the second page, and you're pretty well done with the form, because the first page is pretty generic in job title, type of business, period of employment, and then the next page you get into what was listed as your number one job, and then it goes through. So if you've had 10 different jobs, then you would need to fill out pages for each of those jobs. If you only had one job, then you only had to fill out one. But you can, and now what can and should happen on these at times is, if you work for one employer over the last 15 years, but your job title has changed. So, if you went from an assembly line worker, I worked for, when I was going to Murray State University, and even a little bit after that, before I went to law school, to actually save up money to be able to go to law school, I worked at Brick and Stratton here in Murray, and there were several people who worked on the assembly line, and then went to classes, training, and went up into more of a maintenance thing. So if you're on an assembly line for, years 10 through 15, but then the most recent 10 years you've been doing maintenance work, then you would fill out for two forms, one job title for the assembly line, one job title for the maintenance work.
That makes a lot of sense. Now, the one thing you said is because it helps them determine what kind of skills you developed. How does that really come into play with Social Security disability benefits? What does my skill level really have to do with it if I'm injured?
With Social Security disability, they're looking at a variety of things, but one thing is, can you go back to, depending on your age, standards change for Social Security disability based on your age, but as you get older, what they're looking at is, can you go back to the type of work that you've performed in the past? And if the answer to that is no, then they say, well, are you able to go into a physical job that your previous work gives you transferable skills into this other work? Because someone who has experience and has those skills has a better chance of getting a job than someone who's never worked in that industry before, even if it's in a lighter capacity from that. So that's what they're kind of looking at is if you cannot go back to doing the jobs you've done in the past, do those jobs give you a leg up, transferable skills into a job that you can physically do? And if so, then that can affect whether you get disability or not.
So if I were in heavy construction and that was the bulk of my career, I got injured, maybe I've got a back injury or a neck injury of some sort, my transitioning into an office job, not really transitional skills, not really something I would have learned out there in heavy construction to operate in the office environment necessarily.
Correct. Exactly. And that's it. But if you were working in a more of a lighter duty position, but you were managing in an industry that where you were managing employees and in a field where there's same thing in that sedentary position, in a sedentary or sit down position, and you can do the sedentary job, and now you've got all these skills from that industry. It could be like a telephone industry or computer programming type industry, and so you can do this less physically demanding job, then you probably are going to be found not disabled in that setting. So that's what they're looking for to some extent, the physical requirements and the skills that you've learned.
Okay, yeah, because I see on this page it's talking about, how many hours each day do you walk or stand or kneel or, all these different things. They want to get an idea of kind of what are you physically doing in that role, in that position, right?
Exactly. They're looking at that from that standpoint. And then on your jobs, they're going to look at how that job is performed normally versus how you performed the job too from that. So on the skills and all, they will be looking at that. So there's sometimes people have a job where they're doing the position and they have more lifting than what normally is required in that position. Or they have a job that allows sitting and standing when a lot of jobs in that industry or that field don't allow sitting and standing options. So they're going to look at what the job normally requires versus what you specifically did.
Okay, that makes sense. The one thing that always confused me about this is, every time I've filled out a job application, they've asked for my Social Security number. So I would have thought that the federal government would have already had all of this information, but there's a question of sometimes you get into a situation where there's a parent company and a subsidiary, and maybe if I'm working for the subsidiary, the paycheck's actually coming from the parent, so that can also confuse people.
Correct. I've represented a lot of people where I've gone over their earnings records with them, and I mentioned an employer that's listed on there, and they have no idea who it is. And then when I say where the employer is located, and they say, "Oh, that's I worked at this convenience store, and it was owned by that company." That's from that standpoint. So they, you sometimes have that situation where the paycheck is coming from somebody, but you may work at a pocket shell or something, but there's a corporation that owns multiple ones of the pocket shell or something of that nature. From there, plus what Social Security gets doesn't go into detail. It says who wrote the check, who was the primary employer, and what your annual income was from that job for that year, but it doesn't really say what your job duties were. That's not reported on any of the Social Security documents. So this is where you get they get that information.
That SSA
yeah
3369 is where they get that level of detail.
Where they find out whether you were a cashier, whether you were a stocker, whether you worked assembly line building engines where you're lifting 50-pound parts all day versus at a plastic place where you're lifting 10 pounds.
Okay, that makes a lot of sense. Jeff, these forms, I mean, this is one of the most simple government forms I've ever seen. And I like the fact that it is pretty simple. And that, again, is one of the reasons you all often recommend that, hey, look, that first time through, if it's your first time applying for these benefits, kind of take it on yourself. It's not that you don't want to help them, but again, there may not be a benefit for you helping in the initial stages. And I know we talked about that a little bit at the outset, but let's come back to that topic, right? Because don't let this form scare you.
Exactly.
This form is pretty straightforward.
Yeah, and part of that is, there's sometimes I do get involved at the initial level if I've got someone who has significant mental health issues or intellectual issues, then I'll get involved at the initial level in those type of situations. But normally, if it's just the average person that calls the office, what we're going to do is I'm going to look at this form, and this form says, in this job, did you use machines, tools, or equipment? I'm going to look at my client and say, well, when you were cashier, did you use machines, tools, or equipment? And so I'm essentially asking them and then filling the form out. Now, I may reword things. It's going to be giving the truthful answer, and certainly everything's going to be accurate from that standpoint. But I'm essentially regurgitating in a different fashion, maybe, but essentially what the client's telling me, I'm putting in the form, just maybe worded a little bit differently. And when I tell people on doing this, one of the things I do tell them is, this is talking about the job duties that you did, and you want to make sure you mention the job duties you can no longer do, and what was physically required of you or mentally required of you that you can no longer do in those jobs. A lot of times people, when you fill out a job application, you tend to upplay your part in it and make it seem like you're doing greater than what at least you're overselling, so to speak, because you're trying to obtain employment. With these type of things, you don't want to do that at all. You want to be honest about it, but you don't want to upsell it. You don't want to downsell it. You just want to be honest about it. So, if you are some industries, you have what's called a working foreman. And a lot of times I've represented people that were working foremans, but the work was 90% of it, and the foreman responsibilities were fairly small. Less than 5% of the day they were doing foreman type duties, and really weren't they weren't doing paperwork and all of that. They were just making sure all the workers were they're working like they were supposed to, and that's really overseeing versus filling out any paperwork, doing scheduling and things of that nature. Well, if you focus on the foreman side of it, at least when Social Security's looking at it, they're going to say, well, a foreman normally does this, this, and this, and they're not going to realize that, that was a very small part. And while you may have had the title of foreman, you may not have really been doing true foreman type work from that.
And again, this is a disability application, so you're trying to prove that, hey, I can no longer perform those job duties.
Right.
So better to err on the more conservative side that, hey, this lifting I can't do, this turning or whatever, this activity I can't do. That's the issue that's got me applying for the disability.
Right. Exactly. And this form, it's got the part. First it's a description of what you did all day, and that's where you kind of go into detail. The foreman aspect of this was very small. I just made sure that John Smith was at the spot he's supposed to be at doing his work, and Cheryl is at the spot she's supposed to be at doing her work, and I'm at the spot I'm at doing my work, and taking care of that from that standpoint. And then it talks about using technical skills, but one of the things I see people do is they don't really, and people kind of, they don't downplay what they do as much as they just, they leave things blank at times. They don't fill in because they don't know. One of the things they'd ask is, what's the heaviest weight you lifted? And, they think, people lift some clients of mine have lifted mop buckets. And, they don't really know exactly how much they weigh, and they may underweigh it or may overweigh it from that standpoint. And what you need to do is if you don't know what it is, how much it weighs, you may write down lifted mop bucket, 5-gallon mop bucket. That's going to be fairly heavy. And a lot of people, if you've done it over and over again, you may think it's only 15, 20 pounds, when actually 5 gallons of water is going to weigh much more than 20 pounds. And so make sure you and I tell people this, make sure you fill that in. If you're not sure, write down unsure lifted mop buckets or something like that on there.
Yeah. Don't be dishonest with it, but again, don't omit it, because that could be valuable to your claim, and
Correct.
let the government ask a question if they need it verified.
Yes.
Or clarified.
Exactly. Yeah.
Okay.
And so, and that's where I'm, and I've had clients who had back injuries, and then they have coworkers, the last 6 months of their job, the coworker's taking over the lifting part because they knew the person had a back problem and couldn't lift. So the coworker did the lifting, and they didn't. The job required lifting. They just had a coworker that they were friends with, and the coworker took that on.
And initially they were performing that.
Initially they were performing it, and part of the job required it. They just had the other worker was pitching in and helping them out, and then they not include that in there, and then we have to explain why it wasn't included later on. So if you include what the job requires, if you're having a coworker that's helping out on some of those tasks, but the job requires you to lift 50 pounds, you just got a coworker who's doing that every time, we can address that later on, but the job duties requires the 50-pound lifting. So,
Jeff, at the outset, I mentioned that basically there are kind of three legs of your practice. You've got the regular injury work. Think of it as motor vehicle accidents, car wrecks, motorcycle injuries, big trucking collisions, workers' comp, and then Social Security disability. And we've talked a lot about how the Social Security application is talking about your job. So a lot of times that could be work-related. That's where you actually sustained the injury, right?
it can be, yes.
And so you can actually fill out the application for Social Security disability benefits and the workers' comp claim at the same time, right? I mean, you don't have to wait until one's cleared up or whatever. These things can go on at the same time. Is that correct?
They can go on at the same time from that standpoint. And there are times that even though the client's receiving workers' comp benefits, I will have them go ahead and make the disability application if we know they're going to be totally disabled because of the injury. For the primary reason is because there's going to be a point in time when workers' comp cuts that check off, and it takes a while to get Social Security disability. You get denied the initial time, most likely going to get denied the second time, and then you go to a hearing in front of a judge, and that's where it's granted, or most cases are granted, I should say. But it takes a period of time, and once that workers' comp check is cut off, it's going to take a while to resolve that workers' compensation claim. And, if the client's already in that process and hopefully been granted by the time that check's cut off, even if Social Security is saying, well, you're getting workers' comp, we're not going to pay you until that stops, then you can notify Social Security. They start getting the Social Security disability payment at that point in time, and they don't go a long period of time without any money coming in.
Right. And again, we've talked about this in previous episodes, there's the Social Security wraparound where if you're handling the workers' comp claim and the Social Security disability claim also exists, you really need to word that properly so that one doesn't offset a whole bunch of the income you may be making through the other. I mean, there is an art there. There's a legal process to putting that together properly.
Correct. If you have a Social Security disability claim and a workers' compensation claim, then when you resolve the workers' compensation claim, the language, if it's resolved by settlement agreement anyway, the language in that agreement needs to be worded in certain ways to minimize the effect that will have on your Social Security disability benefits from that standpoint. And if you don't do that, it can be very costly to the client.
Yeah, absolutely. And again, with your 31 years now of experience, I mean, you've been down this road many times, and that's one of the advantages of working with you is that I think it's an advantage anyway, is that you can handle multiple claims at the same time. You can keep it all under one house and keep it well coordinated to make sure those types of mistakes don't occur, because ultimately that could cost your client money if it's just two attorneys not communicating. If you're handling both sides of it, you can make sure it's done properly from the outset. And ultimately, that should be a better deal for your client, I would think, or less risk, maybe.
less risk for the client from that standpoint for sure, because I've had clients who have had other claims that didn't tell me about those until we were well involved in the process. And if I'm handling a workers' compensation claim and then they file for disability and don't tell me they filed for disability, I've had clients file and be granted at the initial process, and me not know anything about them filing and receiving disability, and we be talking settlement figures, in talking about settlement, and then they just happen to say, "Oh well, how does this affect my Social Security disability at all?" And I didn't know you were getting Social Security disability, and so making sure your attorney is aware of that information. If you have two different attorneys, if that's what you want to do, that's fine and dandy. But make sure both are aware of both claims, because they need to coordinate those from that standpoint. And it saves you money, because if I'm getting the records for the workers' compensation claim, I can share those with the other attorney versus them paying again the medical provider to get the exact same records a second time. So it can having one attorney doing both will cut your costs down. Making sure both attorneys know if you have to will help to make sure you're protected, and it may not cut your costs down as much, but it can cut it down somewhat from there, but you can avoid a costly mistake that can occur because one attorney doesn't know the other claims going on.
It makes a lot of sense. It's all about communication typically, and that's when people don't communicate, mistakes happen.
Yeah.
Jeff, let's kind of wrap up the episode with this. I in talking with you over the years and in talking to other attorneys about Social Security disability, it's a frustrating process. It's a drawn-out process. It doesn't move quickly. If you've ever been to DMV, you kind of have a sense of what's going to happen. There's always that challenge that people are going to get frustrated and just decide, you know what, I'm just not going to do it, or they underestimate the time involved. And I think that's the perspective that you bring when you're engaged with a client, is that, hey, I understand the process, I understand how it rolls out, but the other factor here, and this is the one thing that throws me every time we talk about disability, why do so many of these claims get rejected, like you said, the first time, maybe even the second time? I mean, it just seems like the government kind of rubber stamps those things.
To some extent, sadly, I have to agree with you to some extent in that regard. The process needs to be revamped from that standpoint, because it does take a long time from initial application until you're successful. Frequently, it can take a while for that to occur.
That could be a year or two, right?
It could be over a year, easily over a year,
so
and sometimes longer than that. Yes, absolutely.
Having that level of expectation going into this is important.
No, normally I tell clients you expect it a year and a half. A lot of times we can get it resolved a little quicker than that, but a year and a half is a general rule, and it can take longer than that at times. From that perspective, very rarely do I see cases at the reconsideration level that are granted that were denied initially. Does occur occasionally, but it's very rare that I see that occur. In my opinion, they cut that step completely out and not really cause any major hiccups, and you take 3 or 4 months out of the process from that standpoint. And I can't understand what's going on and why it takes so long. I've had cases where the case be at the reconsideration, because that's when I get involved, and I write a letter and say, if you look at your regulations, your own doctors are saying that they're limited to sedentary work or light work, and all their past work's very heavy, and at their age and education level, they should be granted and be denied. And then we filed a request for hearing. It's been a while since this has happened, but I've had them before where I filed a request for hearing, and luckily my letter got in front of somebody at the hearing office, and had them call me up 2-3 months after I filed a request for hearing, when we're still a year away from having the hearing at that point, and call me up and say, we've looked at this and we agree with you, so we're going to go ahead and grant it. And it doesn't occur as often as, frankly, I would like for it to have occurred from that standpoint. But the case never should have been denied at the reconsideration level. and probably should have been granted at the initial level, even in that regard. And to me, it's, and I may, well, I don't guess I'll get in trouble for it, but some may not like what I say from that. But the process right now at the initial and the reconsideration level is the Fox Guardian and Hen House situation, because they have the records reviewed by their own doctors, and their doctors are being paid by the Social Security Administration or those essentially. And, it's amazing that, they hardly ever find anybody to be disabled as far as the restrictions they place. And I've seen situations where I've had an ophthalmologist was the specialist Social Security had to review, or Disability Determination Services, who makes the initial and the recon decision, had the ophthalmologist reviewing and making decisions on somebody with who's had multiple spinal surgeries.
It's close enough for government work, Jeff.
That's the only thing it's close enough for.
You got an eye surgeon dealing with a spinal injury.
Exactly, and it's just, I try to for judges to allow me to either depose or ask these doctors specific questions. Why, as an ophthalmologist, do you think you're qualified to offer an opinion on spinal issues? Still hadn't had a judge require them to do that yet, but that is the whole process needs revamping, in my opinion, to speed the process up.
Absolutely. Well, friends, if you've made it to the end of this episode, the message here is keep the faith. There are attorneys out there that know this practice. They know how to do it well. And Jeff, if somebody wants to get in touch with you, maybe they have questions, maybe they've gotten that denial letter, and it's time for them to engage with an attorney. What's the best way for them to contact you?
Best way to contact me is by phone. Call the office at 270-753-0053. You'll have, in all likelihood, you're going to have a live person answer the phone and talk with you. If I'm available, I'll talk with you. From that's the best way to reach me during business hours. If I do have some people who reach out to me after business hours, and you can do that if you wish to do that, because I know we're talking about disability cases, but I have some clients who work day shift and they have more time at nighttime. And you can reach out to me through by email at jeff@jeffrobertslaw.com, or on my website. There's a contact page there, especially if you're a new client, and if you're on the website, it will ask you some information, and then it will, when you fill that little form out, it will send me notice that somebody's completed that form, and send me an email of your conversation, what you filled out. From that standpoint, and then either myself or somebody from my office will be back in touch with you once we get that completed contact sheet from my website.
Outstanding. And once again, you've got an office. Your primary office is right here in Callaway County. You're based out of Murray, but you also have the other office now up in Christian County, up in Hopkinsville.
Hopkinsville, yes. I've got the satellite office in Hopkinsville that's by appointment only right now there, and then my primary office is in Murray.
Fantastic. Jeff, thanks again for your time. And once again, friends, keep the faith. We'll get you through it. Take care. Bye-bye.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.